Hi, my name is Heather Fritsch and I'm a general practice attorney in Sycamore, Illinois. I have a solo practice out there and part of my practice entails real estate law, and I'm going to talk to you today about the basic components of a deed. When you're handling a residential real estate transaction, whether from the seller's side or the buyer's side, you're going to have to prepare or review a deed. Almost all of your deeds will have the same basic parts. In the upper right-hand corner of your deed, you will have to leave a blank space for the recorder's filing stamp. Each recorder's office in each county has different rules with regard to the size of that blank space. They also have rules with regard to the general format of your deed, with regard to spacing and the borders. So you will want to make sure that you touch base with the recorder's office in the county in which your transaction is located to ensure that you conform with their requirements. So your upper right-hand corner will have the blank white space. Up to the left-hand corner, you will have usually the title of the deed, and then you'll have who prepared it. If you're the seller's attorney, that will be you, when you would put your name and the address there. Underneath that, you would have who the deed will be returned to after it's recorded. If you're the buyer's attorney, you're going to want that deed returned to you. And I do this personally because then you can keep track of the deed and make sure that it is recorded properly and that your client gets their original deed back after the closing. After you receive the original, you can send it to them. Underneath that, you will have to have the information with regard to where the tax bill should be sent and what the grantee's address is. Now, sometimes this seems self-explanatory in that the person taking title is the grantee and that will be their address. But don't make that mistake, as your deed might be returned if you don't have the specific words grantee's address and a name and address there. Your taxes may or may not be going to the same person, so if it's the same person, just put a / grantee's address / taxes to, and then put the name of the buyer and their address. If it's a different person, you'd have the different name and the different address. You want to make sure to have that specific language because some recorder's offices, if they don't see the words grantee's address, they will return it as non-conforming and they will not record it until it's fixed. You don't want a simple mistake like that to cause you issues. After this information, you'll have the body of your deed. In the body of the deed, you're going to have the seller's name and address as well as the buyer's name and address. With both names, you want to make sure that those names are exactly as they are on title. So for the seller, you'll want the name to be exactly to a T, down to the middle initial or no middle initial on that document. You will also, for the buyer, you'll have to make sure that the deed and the title work and the mortgage, if they have one, all conform exactly, even down to the middle initial or if it's Jim or James, etc. You will also, for the seller, if the seller is a trustee or multiple individuals, you'll want to make sure to list what type of individual they are. For example, if you have a husband and a wife, you'll have to say Jim and Mary Smith, comma, husband and wife, and then you'll go on with their address. For the buyers, you'll have to do the same thing, and in addition, you're going to have to say how they are going to take title. There's three main ways that individuals can take title. If you have one person, there's no issue here because they just take title as the individual. If you have multiple people, you'll have to show on the deed how they are taking title. There are three main ways: tenancy by the entirety, tenancy in common, and joint tenants. In tenancy by the entirety, that is a very good way to hold title, but the only way you can hold title by tenancy by the entirety is if you are a husband and wife and the property is your primary residence. The reason this is better than other ways to hold title is because the property is protected from the creditors of the other individual. For example, if Joe Smith has a gambling problem and Mary Smith does not know about it, Joe's creditors cannot come and take their house because Mary also owns his house by the entirety. The other good thing about tenancy by the entirety is there's a right of survivorship. A right of survivorship means that if one of the individuals passes away, the other individual owns the property completely and fully as soon as that person passes away. So if Joe dies, Mary owns that property and it doesn't have to go through the probate estate. The second way to hold title is tenancy in common. In that situation, there is no right of survivorship. So if one individual passes away, and we'll use Jim again, if Jim passes away, the property passes to whoever he leaves it to in his will, and if he does not have a will, it passes to whoever would fall as his heirs under the descent and distribution statutes. This is good for some people if they're buying it as an investment and they want their heirs to receive their portion of it. It's not so good for other people because if you're Mary, the survivor, you could end up owning the property with Jim's 5 children when you didn't want to do that. So that's something to take into account. The third way is joint tenants. And with joint tenants, each of the individuals have to own the equal amount, and there is a right of survivorship. So you could say Mary and Jim each own 50%, and they have a right of survivorship. So you would have, if Jim dies again, Mary would own 100% of that property. It's very important that you advise your client, if you're the buyer's attorney, as to these types of owning property, as it could really make a difference in their lives moving forward. One situation that you'll see a lot is individuals who want to take by tenancy by the entirety, but their wedding isn't scheduled for another month or so after the closing. In that situation, they cannot do so because they're not yet married. So what you would want to do then is either have them take by joint tenants, which is what you usually see because they usually want that right of survivorship, or tenants in common, and then as soon as they're married, you can have them sign a quitclaim deed and have that recorded, and you would deed from them individually to them as tenants by the entirety. After your body of the paragraph where you have that information, you would move on to the common address, so 1234 Mary Lane, Rockford, Illinois, and you would have the PIN, which is the tax identification number. Now, these are important in my opinion because it helps you see what property you're speaking about. However, they're probably rather legally insignificant. What's legally significant is the next thing on the deed, which is the legal description. Your legal description is what actually transfers the property and what controls. And that is 100% necessary. So you'll want to be very careful to review your legal description. And when I'm the buyer's attorney, I ask for the documents from the seller's attorney in advance of the closing, so I can do that without any strain and be able to ensure that this document is correct. Your legal description, in my opinion, should be correct to the comma. Other attorneys aren't quite so picky as I am about it, but if you have a legal description and you have a piece of property that's been transferred, say, 100 times, if you have 100 small changes, you may end up at that 100th transfer with a legal description that is no longer accurate. So there's no reason not to have it completely correct. Additionally, your legal description on any survey and on the title work has to match exactly what's on the deed. After that, you'll have the language stating that the deed is contingent only and subject to only real estate taxes that haven't been paid and covenants and restrictions, etc. of record. After that, you'll have the signature line, and you'll have to make sure that the seller signs exactly how they own title. So back to that middle initial again if it's there, or if he's signing as trustee of his trust, etc. You'll then have a notary paragraph, and notary will notarize that signature, and you'll have to leave a blank space at the bottom, in which, because if your municipality has transfer tax requirements, there will be stamps, which are like small stickers that have to be placed right on that deed, right there at that portion. All of those parts of a deed will be on nearly every single deed, or should be on every single deed that you review or prepare. If they're not, then you might want to consider revising it or fixing it to make sure that they do. They all may be in different orders, but they will all be on that deed. Thank you for listening today, and if you'd like more information on this topic or basic residential real estate law in general, please feel free to check out my book at the ISBA's website, Basic Residential Real Estate Law from Contract to Closing.